Hi everyone, and welcome to this Victoria Law Foundation Law Talk. My name is Wan Tran. I'm the Principal Solicitor at the Young Workers Centre, and I have with me Leon Harper, who is a solicitor, also at the Young Workers Centre. So just a little bit about the Young Workers Centre. We are a one-stop shop for young workers aged 30 and under in Victoria. It's a place for young workers to come to learn more about their workplace rights or who need assistance resolving workplace issues. We provide a community legal centre which is accredited with CLCs Australia and also the Federation of CLCs in Victoria itself. And today we're going to talk to you about the National Employment Standards. So what are the National Employment Standards? Well, they're part of the employment law regulations in Australia. In Australia, employment law is regulated by many pieces of legislation, but the key piece of legislation is the Fair Work Act. Now, the Fair Work Act contains the National Employment Standards. The Fair Work Act also regulates awards and enterprise agreements called enterprise bargaining agreements. It also deals with termination of employment matters, and it also deals with the regulation of unions and industrial associations. There's quite a lot. So today we are just going to cover what the National Employment Standards are.
Before we talk about the National Employment Standards in detail, it's important to have a think about how employment law in Australia works. So you can see on this fetching pyramid design here, we have sort of three different layers of the laws that govern employment in Australia. At the very top of the pyramid, we can see here, we've got contracts. Below that, we have what's called enterprise bargaining agreements and awards. And at the very bottom, we've got what we're going to be talking about today, which is the National Employment Standards. That little arrow is to say that you are here. The National Employment Standards form the absolute base of this pyramid, so you can't go lower than the National Employment Standards. Almost every employee in Australia, except for a few very specific exceptions, the absolute minimum standards of their employment have to meet these National Employment Standards. What comes after that is awards. Awards we'll talk a bit more about in a moment. Awards generally will provide standards that are as good or better than the National Employment Standards. Above them again, we have enterprise bargaining agreements, which will generally be as good or better than awards. And then at the very top, you might have a contract that has terms that are better even than an enterprise bargaining agreement or the National Employment Standards. So I think it's important to see the National Employment Standards as they are the bare minimum that any worker in Australia should be afforded. And that's why they're so important in the Fair Work Act. They're establishing the floor, essentially, the minimum wage. A contract of employment is a contract between an individual worker and their employer. A contract can be a piece of paper that you've signed that says, I agree to do this for this amount of money. It can also include policies that the workplace has, or what we call a course of conduct. So it can be that you show up for a shift every week and you're paid this amount. That becomes a contract, even if you've never actually signed anything. An enterprise bargaining agreement is an agreement between employees of a certain workplace and their workplace. Enterprise bargaining agreements have to be approved by the Fair Work Commission, and workers who are under an enterprise bargaining agreement must be better off overall under that agreement than they would be under the award or the National Employment Standards. So some examples of enterprise bargaining agreements might be places like Coles or Woolworths. Awards, which we also call modern awards, are industry minimum standards. So they apply to all the workplaces that are in an industry unless there's an enterprise bargaining agreement that covers that workplace. I've got a couple of examples here of very common awards. The Fast Food Industry Award, which covers fast food workers. The General Retail Industry Award covers retail workers. All of these things sit above the National Employment Standards, so they generally will improve on them. They'll provide terms that are better than the National Employment Standards. Because again, the National Employment Standards are the bare minimum that all employers need to abide by.
So what are the actual National Employment Standards? There are 11 standards contained within the Fair Work Act. Every employer needs to meet the National Employment Standards. And that's every employer who is covered by the Fair Work Act, which isn't actually every employer in Australia. It is the case that almost every employer in Victoria is covered by the Fair Work Act, except for certain really high-level public servants. It is different in different states. But in Victoria, you can probably be assured that the Fair Work Act would apply to your employer. Not every part of the National Employment Standards covers every worker. So what that means is certain of the National Employment Standards, and we'll go through each of them soon, but certain of the National Employment Standards don't apply to employees who are employed on a casual basis, or may not apply to employees or to workers who work in the on-demand economy. That's people like doing work like Uber driving, because they're not usually considered employees. But generally speaking, most people are employees, and the National Employment Standard would apply to their work. Leon's mentioned before that National Employment Standards are the bare minimum, the absolute basis. Everything else interacts with and should sit above the National Employment Standards. They shouldn't change them or be less than, and they can't, because they are pieces of legislation. So awards and enterprise bargaining agreements and contracts of employment can improve on the National Employment Standards, but they can't alter them and have a worker get less than what the National Employment Standards provide. So as I mentioned before, there are 11 National Employment Standards. The first is maximum weekly hours, and Leon will tell you about them.
So maximum weekly hours refers to, for permanent full-time employee, what the maximum they should be working every week is. So under the Fair Work Act and the National Employment Standards, 38 hours a week is considered to be full-time employment. For everyone who isn't a permanent full-time worker, their maximum weekly hours will be either 38 hours a week or their ordinary hours. Now, certain awards, especially in industries where it's common to have permanent part-time workers, will have different definitions of what these ordinary hours are. Some awards will also allow for averaging hours over fortnights or months. For example, you might do an average of 38 hours over 4 weeks. Maximum weekly hours is really important for determining when someone's working overtime, because under many awards and many enterprise bargaining agreements, workers who are working overtime, so working over 38 hours a week, are entitled to additional penalty rates to recognise that they're doing above and beyond what they should have to be doing.
The next National Employment Standard is the right to request flexible working arrangements. This links directly with the maximum weekly hours and hours of work. Awards will talk about when hours of work can be set. And generally speaking, if you're a full-time employee, you'll work something like 9 till 6 p.m. with 1 hour break in the middle in certain types of usually clerical or office jobs. You might also be working in say a factory when your hours of work might start at 7 and finish at 3, and you'll have set breaks for morning tea, a half-hour lunchtime break, and an afternoon break. But that will all be covered either in an enterprise agreement or in your award about the types of hours of work that you do. But there are circumstances in which you can make a request for flexible working arrangements. You have to have certain eligibilities, which is as listed on the slide. If you've got parenting or caring responsibilities, if you have a disability, if you're 55 years of age or older, or if you're experiencing family violence or providing support to someone who is experiencing family violence. That means that you can make a request to change your working arrangements, and you can make that request about anything. So later starts, earlier finishes, longer hours if you need to take breaks in the middle of the day to accommodate any of those responsibilities. Now, an employer can refuse the flexible working arrangements. They can, of course, agree. They can refuse. If they refuse, they have to do so on reasonable business grounds. The right to request flexible working arrangements, however, is just that. It's a right to make a request. It's not a right to actually have the flexible working arrangements. There isn't currently a great ability under the Fair Work Act to enforce the right to make a request or the right to have flexible working arrangements. And the current federal Labor government, the current Albanese government, has flagged some changes to this standard so that workers can bring a dispute about an employer's refusal to agree to a flexible working arrangement request, to make it more of a right to actually have a flexible working arrangement rather than a right to request it. The next employment standard is about casual conversion.
So casual conversion is in some ways similar to the right to request a flexible working arrangement. Casual employment is less secure than permanent employment. When we talk about permanent or casual employment, what we mean is a permanent employee is someone who's employed somewhere on an ongoing basis. So they will generally work the same hours every week. If they're a permanent full-time employee, that will usually be 38 hours a week. They get things like paid leave, so for sick leave or for annual or holiday leave, and they have job security. So they know that because they have a permanent position, they can't be dismissed or rostered down at the drop of a hat. Casual employees do not have that kind of security. A lot of people will work casually, especially in industries like retail and hospitality. We see it a lot. So they might have very wildly varying hours. They might work 30 hours in one week and 6 hours in another week and not get any shifts at all in the third week. So for a variety of reasons, for most workers, casual employment it's less secure and it's less preferable than permanent employment. Casual employees do receive a 25% casual loading to work that they do. So that means that they're paid a little bit extra, but generally that doesn't make up for the insecurity that they have in their work. Casual conversion means that someone who's an existing casual employee is converted into being a permanent employee, doing the same job with the same hours that they were doing as a casual. So to use an example of someone working as a waiter at a cafe, they might do 2 shifts a week, be paid a certain amount, and when they're converted from being a casual to a permanent employee, nothing changes except potentially their rate of pay and the fact that they're now a permanent employee. There's 2 parts to this part of the National Employment Standards. So first of all, there's times when an employer must offer to convert a casual employee into being a permanent employee. And secondly, there's a time when an employee can request to be converted. So an employer has to offer casual conversion if the employee has been employed there for at least 12 months and they've worked a regular pattern of hours on an ongoing basis, which could continue unadjusted as a permanent employee. So to use our example of the cafe worker, they've worked the same couple of shifts every week. They could go on to work these shifts in the foreseeable future. There's no reason to think that they suddenly won't need a barista for Sunday afternoons, and that would not affect the business's workflow. Employers don't have to offer if it's not reasonable for them to offer. And the Fair Work Act has a little bit of explanation about reasonableness here. An employee can also request casual conversion if they have been employed for at least 12 months and they've worked this regular pattern of hours, again, similar to circumstances in which an employer must offer, and the employer has not previously made an offer of conversion which the employee has rejected. So an employee can't request casual conversion under the National Employment Standards if they've already rejected an offer, essentially. The problem with this is that employees can still only make a request. Because of the way that reasonableness is worded in the Act, it's still relatively straightforward for businesses to reject requests, even where it might not actually be fair that they're rejecting it. So unfortunately, it's a fantastic start to have this right to casual conversion, and it's something that a lot of industrial campaigners and the union movement have fought really hard for, but it's not necessarily quite enough.
The next national employment standard relates to parental leave. Now, this is a right for permanent, which is permanent full-time or part-time employees, to take unpaid parental leave of up to 24 months. 24 months. It's up to 12 months, and then there's a further right at the end of the 12 months to request a further 12 months. So it's a total of 24 months. In certain limited circumstances, some casual employees may also have a right to unpaid parental leave, but the National Employment Standards deals predominantly with permanent employees having a right to unpaid parental leave. It is unpaid. So enterprise bargaining agreements might provide for something greater than the National Employment Standard of 12 months unpaid parental leave. That would include, for example, paid parental leave. And then there's a separate paid parental leave scheme, which is a social security scheme. So it's available through Centrelink. It's not an employment law scheme. The employment law scheme is only an unpaid 12 months of parental leave. What it really means in practice is that a person who who needs to take the parental leave, who is eligible for it, can return to work in the same position that they had prior to taking the leave. Or if the same position no longer exists, then an available position for which the person is qualified, which is closest in status and pay to the pre-parental leave position. There are also rights to things like keeping in touch days, which is that during the 12 months of leave, there's a right to take days off work to ensure that you remain involved in the job and remain trained and up to standard. In order to be eligible for unpaid parental leave, then either a person or their spouse, which includes a de facto spouse, has to be giving birth or adopting a child under the age of 16 years. There has to, the person who wants to take the unpaid parental leave has to have completed 12 months of service with the employer by the expected date of birth or placement or adoption. There are also special circumstances in this particular National Employment Standard that deals with situations like stillbirths or the ending of a pregnancy prior to delivery of a live child, or if children are hospitalised upon birth. And there's also provisions in this particular National Employment Standard that relate to what to do if the job is not safe for a pregnant person. It's fairly involved, but it's an important right. It could be much better in terms of providing paid leave, but the current right relates to unpaid parental leave for at least 12 months. There are all rules around how it works in terms of giving notice and making requests.
So another kind of leave that's enshrined in the National Employment Standards is the right to annual leave. Annual leave might also be called holiday leave or vacation leave or something along those lines. Annual leave is only for permanent employees. Casual employees are not entitled to annual leave. And what annual leave is essentially is paid time off work to do whatever you want, to go on a holiday, to spend some time with your friends, to get all of those doctor's appointments out of the way. Annual leave is an entitlement for 4 weeks for most permanent full-time workers. It can be an entitlement of 5 weeks for shift workers. What a shift worker is will depend on the award that covers that worker. It'll generally refer to workers who are starting work really late at night, so doing, night duties at a hospital or something like that. Permanent part-time employees will accrue annual leave pro rata, which means that they'll accrue it at a rate that's proportional to how much they work. So someone who's working 3 days a week will effectively accrue enough leave so that they can take 4 weeks of leave of 3 days. It accrues throughout the year, so you don't get it as soon as you start working, but as you work, you will start to accrue annual leave if you're a permanent employee. Really importantly, any accrued but untaken annual leave must be paid out at the end of employment. Whether you resign, whether you're dismissed from your employment, even if you're dismissed from your employment for serious misconduct, untaken annual leave must be paid out. Enterprise bargaining agreements can also provide for additional leave. So under some enterprise bargaining agreements, you might receive 5 weeks or 6 weeks of annual leave, but under the National Employment Standards, every permanent full-time Australian worker is entitled to at least 4 weeks of annual leave. Another kind of leave that's enshrined under the National Employment Standards is personal leave, which is quite a large area that Juan's about to take us through.
Personal leave is a term for lots of different groups of leave, lots of different kinds of leave all grouped together under the banner of personal leave. The key one that personal leave covers is sick leave or carers leave. In general terms, in order to access personal leave, which has a sense of an emergency to it. So with annual leave, there are requirements to give notice and agree with the employer about the time that you would take annual leave. Personal leave, you take it when you need it, and you just have to give notice as soon as possible. You also have to provide evidence that would satisfy a reasonable person of the need to take that personal leave. The types of evidence that should satisfy a reasonable person would be something like a medical certificate, or sometimes a statutory declaration about something that's happened that has meant that you need to take the personal leave. In general terms, the personal leave is for permanent, full-time and part-time employees paid personal leave, and there is an entitlement to 10 days of paid personal and careless leave each year. A casual employee can be entitled to unpaid careless leave. There are certain rules around how that can be taken on. It's only 2 days per year, but per occasion for a casual employee to take unpaid careless leave. The other kinds of personal leave that can be taken under the National Employment Standards are compassionate leave. Compassionate leave is what can be taken if a family member or a household member dies or becomes seriously ill or injured, and it's paid leave for permanent, full-time and part-time employees, and 2 days can be taken per occasion if need. And then there's also family and domestic violence leave, which is available under the National Employment Standards under the personal leave grouping. It is 5 days of unpaid leave per year to deal with matters that arise from experiencing family and domestic violence. And it can include things like attending court hearings or accessing support services.
So yet another kind of leave under the National Employment Standards is what's called community service leave. So this states that an employee can be absent from work when they're engaging in community service, and that's paid leave for permanent employees. Community service there's a few definitions of what community service is under the Act. Jury duty is one example. So if you're required to sit on a jury, if you're called to observe a criminal trial or something like that, then you have an entitlement to be paid community service leave if you're a permanent employee, so that you can do that, because part of the National Employment Standards is recognizing there are important things that people might have to do for the good of society, even during their work time. Voluntary emergency management activity is also covered by community service leave. A good example of that is CFA volunteer firefighters who might be mobilized to keep their communities and their areas safe. They receive paid leave. The Act allows for other activities to be prescribed as community service leave. Something that isn't in the National Employment Standards but is very common under enterprise bargaining agreements is blood donor leave as part of community service leave. And that sort of thing can also be contained in contracts and policies of individual workplaces.
So the last type of leave that the National Employment Standards deals with is long service leave. So what is long service leave? It's an entitlement to paid leave after you've been continuously employed, usually with one employer for a period of time, usually 7 years. There are also rules about being paid out accrued but untaken long service leave if your employment ends after a certain period of time. Some industries also have portable long service leave. That's not usually dealt with by the National Employment Standards in relation to long service leave. The long service leave standard actually generally just refers to either awards or state legislation. There was an intention to nationalise long service leave rules and have it the same all across Australia when the Fair Work Act was written back in 2009. But that didn't eventuate because the states couldn't quite agree on it. So currently long service leave depends on what state laws say or what an award says. In Victoria, the long service leave provisions are governed by the Long Service Leave Act of 2018. Almost all workers in Victoria actually have an entitlement to long service leave. That includes, of course, permanent, full-time and part-time employees, but it also includes casual, seasonal and fixed-term employees. And there are certain set laws about that. Generally speaking, what long service leave is an ability to take quite a long period of time off work after at least 7 years continuous service in Victoria. And the laws are very specific about what the leave is and what the entitlements are.
So another very important thing covered by the National Employment Standards is public holidays. We all probably know a bit about what a public holiday is, but legally, a public holiday is essentially a day that an employee is entitled to be absent from work. Some public holidays are nationwide, like Christmas Day, Easter, Anzac Day, and some are set by states. So, for example, in Victoria, we have Melbourne Cup Day and the grand final public holiday. Every year, each state government will publish a list of all the public holidays that are in that year, and those are gazetted public holidays. Very occasionally, one of those holidays might be moved. For example, the grand final public holiday was moved during COVID initially to reflect that the grand final itself had been moved. And sometimes extra public holidays might pop up. For example, the Queen's Memorial Day after the Queen of England passed away. An employee is entitled to be absent from work on public holidays and to be paid for that time, so as though they were working. An employer can request an employee to attend work on that public holiday. The employee can refuse if the request is not reasonable or if their refusal is reasonable. Those two things sound like they're the same thing, but it's a slightly different test in each case. If an employee does have to work on a public holiday, most awards will apply for fairly generous penalty rates for work performed on public holidays. So even if you have to work, depending on the award, you might be being paid double time or perhaps even more.
So the National Employment Standards also deals with what happens when employment ends. And there are two key things that the National Employment Standards deal with here. One is about notice of termination of employment, and the other is about redundancy payments. So what's notice? Notice is letting someone know that their employment has ended. And notice under the National Employment Standard has to be written and it has to be actual. What that means is you can't give notice by sending something to an old address, for example. You have to make sure that it's actually drawn to the attention of the person who it affects. And notice can't be given after the employment ends. So that means that you can't say you can't say today that someone's employment ended yesterday. It has to end after the notice is given. The alternative to giving actual notice is making a payment in lieu of notice. The amount of notice that you're entitled to depends on how long you've been employed with an employer. So if you've been employed for less than 1 year, then you'd be entitled to at least 1 week's notice. And the alternative to that is, instead of being given that 1 week notice, so today saying your employment ends in a week's time, an employer can say that your employment ends today, but pay you the equivalent of 1 week's wages, the equivalent of the notice you should have received. That's called a payment in lieu of notice. The National Employment Standards doesn't have any rules about the amount of notice that an employee must give to their employer in order to end their employment. That's something that's dealt with in an award maybe, or in enterprise agreements, or in a contract of employment. And generally speaking, what happens is people consider that the amount of notice that an employer has to give an employee is the same for an employee to give to their employer to end their employment. Then there's the standard about redundancy pay. The standard talks about what redundancy is, but it's defined actually in another section of the Fair Labor Act. It's where an employer no longer requires the employee's job to be done by anyone, or where the employer becomes bankrupt or insolvent. Redundancy pay is, again, like termination notice, based on how long you've been employed by your employer. Depends on your years of service. You have to have been employed for at least 1 year in order to get redundancy payment, but there are certain situations in which there's no redundancy payment payable. Casual employees, unfortunately, don't get redundancy pay, nor do apprentices. Employees of small businesses, which is defined by the Fair Work Act as being fewer than 15 employees, also don't get access to redundancy pay. And of course, people employed for less than 1 year. Some awards have industry-specific redundancy schemes, which provide for greater entitlements than the national employment standards. For example, the Textile Clothing and Footwear Award allows for redundancy payments to businesses that have fewer than 15 employees, and then some awards provide for greater entitlements to redundancy payments.
And the final, for now at least, national employment standard that we have is a standard around information statements. These are two statements that are prepared by the Fair Work Ombudsman that need to be provided to new employees at the beginning of their employment. So there's two statements here. There's the Fair Work Information Statement, which essentially summarises a lot of employees' rights under the National Employment Standards and under the Fair Work Act. There's also the Casual Employment Information Statement, which summarises some of the areas that are specific to casual employees. So casual employees must be given both of these. Permanent employees obviously don't need to be given the Casual Employment Standard statement, but they do have to be given the Fair Work Information Statement. And those should be provided to all new employees, whether in hard copy or emailed to them. We've brought you back to this slide, the pyramid that we showed you at the start, to really underscore that all of the things that we've just talked about, they might seem like a bit of a random collection of rights, parental leave, payment on termination, annual leave, some statements that employers have to give you. It all seems a bit random, but the reason that all of this is grouped together is that this is the bare minimum that employees in Australia are entitled to. This is what our politicians, our thinkers, our academics have all put their heads together and said, this is the bare minimum that workers should be getting. Many of us are of the view that there are some other things that should be included in these bare minimums, but these kinds of protections have been really hard fought for by workers, by unions, by campaigners through the years. And even though a lot of them are, again, a bit of a random assortment, they all come together to really create a basic minimum in Australia that a lot of other countries just don't have. These standards will then be improved on by the industry-specific awards, by employers who have enterprise bargaining agreements, and by individual contracts between employer and employee. But the national employment standards, they create a floor that absolutely everyone deserves and is entitled to under the law.
So that's everything from us at the Young Workers Centre about the National Employment Standard. We hope to be back to tell you some more about other important employment law rights that you have because you were a worker in Australia. Thanks very much.